Okay, welcome guys. I appreciate you taking time to be here tonight. We've got a really exciting program for you. Once you get past this class, you'll have a lot of fun. But my name is Richard Weeks. I'm the office manager for Investable Realty. And this is a TREC approved class, so you'll get 1 hour of CE if you are a real estate agent. We're going to go through all 24 paragraphs. That's a lot to do in an hour. But if you have any questions, we'll try to get those in. But if we don't get to you, you can see me after the program. I'll be around, and I'll be happy to answer questions. We gave you a handout of just the changes to the contract. But as you can see, this document is about 27 pages, double-sided. So if you want a copy of this presentation, just send me an email. And my address is on that front page there, and I'll send you the whole presentation. So basically what we did when we wrote the class is we took every paragraph and we kind of broke it down into layman's terms, so the explanation will be a little easier. So we're going to skip the changes, and we'll actually go through the changes as we go through the contract. So please feel free to ask questions, and we're going to try to keep on the schedule to go through all 24 paragraphs. So some of it will hit pretty much at a high level, and then the changes will definitely bring those to your attention so that you'll know what those changes are. Okay? Everybody all right? Okay, fantastic. Okay, so paragraph 1 is the parties to the contract. You want to make sure that you use the buyers and sellers' legal names. Those are the names that the title company is going to use to draw up the docs. So if you don't really know your buyer's legal name, you might want to ask them, because you don't want to get to closing and everything's done wrong and they got to start all over. Okay? Paragraph 2 is the property. You need a legal description of the property, either lot and block, which is probably 99% of the time, or meets and bounds if it's typically an acreage type property. So that's paragraph 2A. Paragraph 2B and C, those are the improvements and the accessories. So if any of those items exist with the property, then they stay with the property unless the seller excludes those items. So if you're going to do any exclusions of any of those items, if they exist, then we need to put it in the next paragraph, which is paragraph D. So right here in paragraph D, this is where you would list all your exclusions, okay? Now the next paragraph, paragraph E, is the reservation of mineral rights. So the mineral rights, if they exist, convey with the property unless the seller excludes those by using the TREC promulgated mineral exclusions. But it's always been the case, but the broker-lawyer committee just wanted to add that to the contract so that it avoids any possible misunderstanding regarding those mineral rights. Typically, they don't have them, but if they do convey with the property, okay? Then paragraph 3 is the sales price. It's made up of 3 things: how much cash they're putting down, how much they're financing, and then what the total sales price is. Paragraph 4 applies if you're a real estate agent. If you're a real estate agent and you are a party to the transaction, the buyer or the seller, or if you're representing a family member who is a buyer or seller, then as an agent, we need to disclose that. And what you have to disclose is yourself, your parents, your spouse, and your children. Anybody else, you may or may not want to exclude those. That would be up to you. So if it's a cousin or... Pardon me? No, you're not required to, but I would still do it. Brother-in-law, you're not required to, but I would still do it. Okay. If you read the TREC rules, the TREC rule says the first degree of consanguinity, which means spouse, parents, or children. Okay. Okay, paragraph 5, this is the one that you really need to be attentive to, because this is, in my opinion, the biggest change that was made in the contract. Has to do with the earnest money. So how much earnest money and who the escrow agent, that hasn't changed. What has changed in this paragraph is now the buyer has 3 days after the effective date to deliver that earnest money to the title company, okay? Now, if the 3rd day falls on a Saturday, Sunday, or legal holiday, then it's the day following that it has to be delivered, okay? And then it goes on to say that time is of the essence, which means 3 days means 3 days, not 3.5, not 3 days and 5 minutes. So you got to keep in mind as the buyer or the buyer's agent to get that earnest money delivered to the title company, excuse me, and receipted on or before the expiration of that day, okay? So that gives the seller the right to terminate if they choose. So after that 3rd day, if they don't have the earnest money delivered, the seller has the right to terminate. And they just send over a termination notice. There's no real TREC form as of today, but there will be soon because TREC is considering approving a new form that will allow that seller or give them the means to do it. Right now, all you'd have to do is send the buyer or the buyer's agent an email telling them that you're terminating the contract, okay? But if you don't get the termination to the buyer before the buyer gets over to the title company with that earnest money check, then they haven't terminated. So it's kind of a race. If after day 3, the buyer can get the earnest money delivered faster than the seller can terminate. So keep that in mind. It's not just a slam dunk. You've got to get that notice to the buyer or the buyer's agent that you are terminating. Any questions on that? Just be cognizant of that. This is the first time that the seller has an unrestricted right in this contract to terminate for non-performance. Okay. So you can see this is kind of lengthy. So like I said, if you want copies, just send me an email. Okay, the next paragraph is paragraph 6, which she talks about the title policy and the survey. Who's going to pay for the title policy and who's going to issue the title policy? So typically the escrow agent in paragraph 5 is also who's going to deliver, who's going to provide the title policy in paragraph 6. They made a change in paragraph 8 where they kind of simplified it to say if in fact there's going to be survey deletion or not, and then also who's going to pay for that survey deletion. So if you remember, the old paragraph in the old contract was really worded quite differently from that. And I think this is a better explanation. So everybody understands survey deletion coverage, what that buys you? Or, okay, let's say you have a car insurance, okay, and then you want to add something to it, like if your car is in a wreck, that you get a rental car paid for. Okay, what the survey deletion coverage is the survey is not covered in the title policy unless you buy this rider, or what's called survey deletion coverage. So that survey deletion coverage would come into effect if the surveyor messed up, and it would cover if there's encroachments or encumbrances on that survey. Okay, it's always a good idea to recommend to your buyer that they buy it. It's very inexpensive. It's 5% of the cost of the title insurance policy. So $100,000 policy would probably cost you about $48 or something like that. Okay. And then paragraph 9, this is a change where the mineral rights were never covered under the title policy. They just spelled that out in this paragraph to let the buyer know if there's any kind of disputes over mineral rights, you're not going to make a claim against your title policy on that. Okay, the commitment, there's been just one small little change in there. The title company still has 20 days to get the title commitment delivered to the buyer after they receive the contract, not the effective date of the contract. But after they receive it, they have 20 days to get the title commitment to the buyer. And then there used to be a sentence in here that if if the title commitment wasn't delivered due to factors beyond the seller's control, they took that verbiage out. So now there's no out for the seller to extend the delivery of that title commitment. So if it's not delivered, then they could extend it up to 15 days or 3 days before closing. But if it's still not delivered within those time frames, then the buyer can terminate the contract and get their earnest money back. Okay, survey, that didn't change. Paragraph 1 says that the seller is going to provide their current survey and a T47 affidavit. That is just an affidavit where the seller says, to the best of my knowledge, nothing has changed on this survey since it was pulled. And that document has to be notarized. So if box 1 is checked, then the seller has to provide the survey and the T47, or the buyer can request a brand new survey at the seller's expense. Okay, so that, no change there. Paragraph 2 says that the buyer is going to pay for a new survey, and paragraph 3 says that the seller is going to pay for a new survey. Okay, and let's go back to that option 1. If that survey and that T47 are delivered in time, the title company and the lender, or lenders, if there's more than one lender, they have to approve that survey. If they don't, then that last box says who's going to pay for a new one. But it still has to be delivered, or the seller's going to be on the hook for a new one. Yes?
Why don't they have a box for already have, like they do for some of the other things, because they didn't include that on the last one?
Well, that pretty much is number 1, with the caveat that you have to have that T47 also, okay? But there's no box for if you don't want a survey, and sometimes investors will buy properties without surveys. So, you know, if it's a cash deal, then you may or may not want a survey. If there's a loan involved, then you're definitely going to have a survey, because the lender's not going to fund that loan without a survey. Okay. But I don't know why. Maybe it's a good question to bring up to the broker-lawyer committee. Okay, objections. This paragraph calls for a couple of places for the buyer to provide information. The first one is activities, if you're going to be using the property in any kind of activity outside of just living there. And a lot of times investors, it might be a good idea to specify in that blank line that you intend to lease that property out, that you're going to, it's a rental property. Because you might buy the property and then you find out, well, you got to live there 6 months before you're able to lease it out. And you know, if you're the buyer's agent and your buyer has to sit on that property for 6 months, they might not be very happy with you. Okay. And then the second blank is how many days that the buyer has to make objections in writing to any discrepancies in the title commitment, the survey, or the exception documents. Okay. And then you'll see down here in the bottom where the stuff in green, it might be kind of hard to see, but all that big block of verbiage is the change that they made to the contract. And basically what it's saying is that the seller has 15 days to cure any objections that they receive in writing from the buyer. And if they cannot cure those, then the buyer has the option to terminate the contract or extend how many days the seller has to cure those. And then another thing is that if the seller incurs any expenses curing these items, then they don't have to. They can just say, I'm not going to do it. You can either buy the property as it is, waive your rights, or do whatever you want. I'm not going to spend any money to cure those things. Okay. Okay, title notices. This is just a whole bunch of different paragraphs where I just kind of call it a catch-all paragraph, where they have a whole bunch of different notices that have to be provided to a buyer based on other types of state laws. These are not TREC rules. These are not the Texas Real Estate License Act law. This might be from the property code or the water code or some other state government agency that requires certain things to be done. The first thing, number one, is you have to tell a buyer in writing to get either an abstract of title or get title insurance. That's what that one does. Number two, specifies if the property is or is not in a mandatory homeowners association. And then it goes out to spell out in the bold print that if it is a mandatory homeowner association, Mr. Buyer, and you don't pay your homeowners association fees, they can foreclose on you, okay? And then at the end, it says if you have any concerns, fill out the TREC promulgated addendum for property subject to a mandatory homeowners association. And most buyers will do that. Okay, statutory tax districts. These are MUDs, or municipal utility districts, for properties that are in unincorporated area and they buy their water, their sewage, their flood control, their drainage from a municipal utility district. So that lets the buyer know that if the property is in a MUD, that there could be standby fees, what the bond rate is, how much bonds have been issued, and how much has been spent. So, and that's a separate form that you'd have to provide. Paragraph 4 talks about tide water. Doesn't really apply to us here, but if you're in an area where the property could be affected by tidal water, like a hurricane, if the vegetation line changes and now your property line is the beach, then you pretty much just lost your property. Paragraph 5 talks about annexation. If your property is in an extraterritorial jurisdiction of a city, so you're in an unincorporated area, there's a possibility that you could be annexed. The next one, the property located in a certified service area or utility service provider. The state licensed different companies to provide water and sewer to areas, certain areas, and it lets the buyer know if you're in one of these areas, there is going to be a fee to hook you up to get water and sewer. Number 9 is a notice about a public improvement district. If the property is in a public improvement district or a PID, it's letting the buyer know that there's going to be an assessment and they're going to have to pay their portion of that assessment. So if you have a subdivision and 51% of the property owners decide, like, let's say that they want a real nice fancy boulevard as you enter the subdivision, and 51% of the people vote for it, and it costs X number of dollars, and you divide that by how many people live there, and it's going to cost everybody, say, $1,000, then you got to pay that $1,000, okay? Transfer fees, these are private transfer fees. There's no state transfer fee. So pretty much every 2 years, the legislature tries to pass a transfer fee so that every time a property would be sold, they're going to collect a little bit of money. But this is not what this paragraph is about. This is about if it's a private transfer, then it lets you know that you're going to have to pay that fee. Number 9 talks about a propane gas system service area. Now, this isn't to be confused with somebody that has a propane tank in their yard. That's not what this paragraph is about. If you have a gathering center and they service a bunch of different homes with propane gas, not natural gas, then there's a disclosure that you have to be made, and it tells you in the notes here what that form is. So everybody's okay with that? So just because you see a propane tank in somebody's yard, that doesn't mean that you have to make that disclosure, but the disclosures there are letting them know. Okay, paragraph 10 talks about low water fluctuations. This was passed in 2015. It went into effect in our 2015 contract, and it lets a property owner know that if you live in a body of water, if you live in a house that is next to a body of water that is at least, how many does it say? 5,000 acre feet, and that's a lot. That's a big body of water. Okay, so like Louisville would qualify, White Rock Lake would not qualify. There's got to be a big body of water, and basically what this paragraph is telling the buyer: if we don't get a lot of rain, the water level is going to go down. If we get a whole lot of rain, the water level is going to go up. So that's your state legislature at work for you. Okay, property condition, paragraph 7A says that the seller has to make the property available to be shown at reasonable times, not just once, but as many times as the buyer or the buyer's agents want to inspect that property. And it also says that existing utilities need to be turned on. Okay, so if you have electricity and water, then electricity and water need to be turned on. You don't have to run gas because you don't have existing gas, but whatever existing utilities have to be turned on. And then last 2015, they also added a paragraph dealing with hydrostatic testing. So if the buyer plans to do hydrostatic testing, they need to get the seller's approval. And then it also has to say who's going to pay for the test, and then who's going to pay for any damages that may or may not be caused by that test. There is a TREC promulgated addendum now that handles that for you. So. Okay, paragraph 7B is the seller's disclosure. This is part of the Texas Property Code that a seller has to provide a seller's disclosure. If you represent the seller, the best box to see checked is number 1, that the buyer has already received that seller's disclosure. Box B says that they have not received it, but they have X number of days to get it to the buyer. And then once the buyer receives it, they have 7 days to terminate the contract for any reason. So if box 2 is checked, you just gave that buyer a free 7-day option period from the time they get the seller's disclosure. Okay? And then number 3 says that the seller is not required to provide one. And they're not required to provide one if they are in California and they never saw the house, right? No, it's not right. If they're in California and they never saw the house, they still have to provide a seller's disclosure. You don't provide a seller's disclosure if it's a foreclosure, an estate, or a new home. Okay, everybody else. And you should encourage your sellers to provide one if they say, no, I'm not going to do that. I've never seen the house. Well, then just answer the questions truthfully. That's all you have to do. There's a box for unknown. If you have to check that box 30 times, then check it. A lot of lawsuits are as a result of the seller's disclosure. Okay, 7C talks about the lead-based paint disclosure. Any house built before 1978, the seller has to provide a lead-based paint disclosure. And 7D talks about accepting the property. The contract that we use, the TREC promulgated contract, is an as-is contract. And that's the box you check, it's as is. And that sometimes gives buyers heartburn. Well, I have to buy the property as is. Yes, you do, but we'll explain when we get to paragraph 23 that you will have an out, okay? So box 1, you check it as is. Box 2, it's still as is, but before the contract's even accepted, you say, I accept it as is, providing you do the following specific repairs and treatments. Like, if you know that in your mind you're not going to buy that house unless they put a new roof, then you put in there, seller to replace the roof. And then that way, if the seller says no, then you just stop. You don't write out a check for the earnest money. You don't worry about the option fee. You don't worry about getting insurance. You don't worry about any of those things, okay?
Does the fact that you fill out some repairs there negate your ability to make a repair addendum later?
No. That's just things that say it's visual. You haven't inspected the property, and it doesn't give, the rest of that paragraph talks about how you can get it. If you do an option correctly, then you can still come back and ask for things that you didn't know about. These are just things that you might see, or maybe you go through the house and you know, I'm so mechanically declined, I wouldn't know until I had an inspection. But if I went into a kitchen and I saw that the window was broken, I would say replace the window in the kitchen. Okay? Does that answer it okay? All right. Okay, paragraph E talks about lender-required repairs. Now, these are not repairs that the buyer wants. These are repairs that the lender says, if you don't do these, we're not going to give you the loan, okay? So either party can pay for them, or neither party can pay for them. If the seller says, I'm not paying, and the buyer says, I'm not paying, then the buyer can terminate the contract and get their money back, earnest money back, okay? Or if the cost of the repairs exceeds 5% of the sales price, then the buyer can say, no, that's too much. I don't want the house anymore. I'm terminating. Give me my earnest money back. Okay, completion of repairs and treatments. This paragraph just basically says that the seller's going to complete all the repairs prior to closing, that they're going to pull the permits, and that they're going to have people that are licensed or people that are engaged in that type of activity. So let's say that it's a plumbing problem, then you have to have a licensed plumber make that repair. Or it's an electrical problem, then you have to have an electrician make that repair. What if it's just replacing or patching a hole in the wall, and the seller says, I can do that, but the seller's a CPA. So that's not their day-to-day work, patching holes in walls. So according to the contract, you'd have to hire somebody to do those repairs, okay? Environmental matters. If the buyer suspects that there's endangered species, wetlands, or toxic waste on the property, they can have a test run. They're pretty expensive. I personally don't know anybody that's ever done that. And if it comes out that, yes, there is a endangered species on the property, then they can terminate the contract and get their earnest money back. The residential service contract is just basically a home warranty and how much the seller's going to pay for the home warranty. It's always a good idea to have that home warranty in place. It definitely mitigates your risk. Okay? And most E&O companies, if a home warranty is in place, you might not have to pay a deductible on a lawsuit. The broker fees, this just says that broker fees are not part of this contract. How a buyer's agent or a seller's agent gets paid is not part of this contract. That's handled somewhere else. That's going to be in your listing agreement and your buyer's representation agreement. Okay, closing. We're going to close on or before a certain date, or within 7 days after the objections made in paragraph 6D, where we talked about the objections have been done. Okay. So if we don't close, if say we're supposed to close today and we didn't close today, is the contract terminated? Yes or no? No, it's not terminated, not automatically. Now, paragraph 15, the default says what you might do, but Just because you don't close today doesn't mean that it's automatically terminated. There could be some reason. Maybe the buyer was on their way to closing and they got in a car wreck and they couldn't get to closing, or there's some reason. But you as an agent or you as a buyer or seller want to, if you know that you're not going to close on that date, you want to extend that date so that you're not out of contract and there's not any kind of dispute about is the contract terminated or not. And then if you have that earnest money hanging out there and the buyer doesn't release that earnest money, and then you try to sell that property to someone else with that earnest money issue hanging out there, you could have some big problems there also. Okay, what happens at closing? The seller's going to execute and deliver a general warranty deed. The buyer's going to pay in good funds, and good funds are defined by the title company. You think a suitcase full of money is good funds? Probably not. They don't want $200,000 in a suitcase sitting in their office over the weekend. So they're going to pay in good funds, whatever the title company says. At closing, they're going to sign any paperwork that the title company says is necessary to close and fund this transaction. There's not going to be any liens on the property that cannot be cleared with the proceeds that the seller is going to receive at closing. And then the last thing, if the property is currently leased, then the security deposit is going to be transferred to the buyer, and then the buyer has to send a signed letter to the tenant letting them know that they are the new owners and they have the security deposit and how much the security deposit is. Okay, possession. When is possession going to take place? Either at closing and funding or according to the terms of a temporary lease. So you just check the appropriate box. So if you know that the seller is going to stay in that house after closing, you definitely want to get a temporary lease. Or if the buyer is going to move in before closing, you definitely want to get a temporary lease in place. Otherwise, you have a tenant at sufferance, and getting them out is like going through the eviction process. And then you could also have some insurance issues. You see that bold print in that paragraph lets you know that, okay? Any questions on that, possession? Paragraph 11, special provisions. If you have any kind of factual statements or business details that you need to add to the transaction, then that's where you would put them. And if you're a real estate agent, you want to be very, very careful what you put in special provisions so that you're not accused of practicing law without a license. So be very careful. And if there's a TREC addendum that's in place, then you would never write verbiage in special provisions that would be covered by that addendum to the contract. Okay.
So question there. So let's say you buy a house in a foreclosure, is it mandatory to honor the lease from the previous owner?
Yes. If it's a foreclosure, then there's a letter. Are you a real estate agent?
No.
Okay. There is, if you're a real estate agent and you're a member of the Texas Association of Realtors, there is a form to let them know that it was bought in foreclosure and it gives them X number of days to get out. But you can't just kick them out. Okay. And if you really want to know a lot about, just Google Texas Property Code leases and read all that. Okay. Okay, paragraph 12 deals with closing costs and how much of a closing cost the seller may or may not pay. So if the seller's paying part of the closing cost, you would just list it there. All right? So if you represent the buyer or the seller, or especially if you represent the buyer, you don't want to put too much in that blank line and you don't want to put too little. You probably want to ask the lender how much they will allow for the seller to pay, because if you've negotiated a price based on the seller's contribution, if you don't use all that money, let's say you put $6,000 in there and you adjust the sales price accordingly, and the lender will only let them use $3,000, then they're not going to write a check for $3,000 to the buyer at closing. Your buyer just basically lost that $3,000. So just work with the lenders and use good lenders, and we got some here tonight. Prorations, it basically says that the title company is going to prorate all the taxes, HOA fees, there's propane in the tank, all those kinds of things that have to be prorated. The seller owns the property through the day of closing, so the title company takes care of all those prorations for you. And then it goes on to say that if they prorate the taxes wrong and there's a little discrepancy, then the buyer and the seller work that out after closing. Casualty losses, what happens if the property is damaged or destroyed after the effective date? There's several options. Number one, the buyer can terminate the contract and get their earnest money back. You could extend the time of performance up to 15 days, and that gives the seller time to make those repairs. Or lastly, you can take the property as it is and get the insurance company to approve that they're going to pay the proceeds to you. The seller would pay the deductible, and then you get it repaired after closing. Paragraph 15 talks about defaults. If the buyer or the seller don't perform, this is the paragraph you go to when you see a lawyer about what your remedies are. And basically, you can get the earnest money back, you can sue for specific performance, or you could sue for specific performance and liquidating damages. Probably not a good idea. Probably best just to go about your business. Mediation, the state of Texas likes for people to mediate before they start suing each other, so this paragraph says that that's what you're going to do. The downside is that mediation is not binding, so you go through the mediation process. The mediator listens to the buyer, the mediator listens to the seller, they make a decision. The party that was not favorable to the mediator's decision said, heck with it, I'm going to sue you anyway. So it's not binding. So most times a new home builder will not go through the mediation process. They'll say, we'll arbitrate, but we will not mediate, because arbitration is binding, okay? Who's the world's famous arbitrator? Judge Judy? Yep. Her decisions are binding. Attorney fees. A buyer, seller, listing broker, other broker, or escrow agent who prevails in a lawsuit are entitled to reasonable attorney fees. Okay, escrow. Okay, the escrow talks about, number one, that the title company is not a party to the transaction. They have no responsibility for the buyer or the seller performing. Okay, so that's the first thing. Paragraph 18B talks about expenses. If they've incurred any expenses on behalf of one of the parties, they're entitled to have that expense paid by the party, or they could deduct it from the earnest money if that party is due the earnest money. So let's say you have a seller who ordered a survey and the title company paid the survey, it was $300. And there's $5,000 earnest money. But the $5,000 earnest money is going to go to the seller, not the buyer. The title company cannot deduct that $3,000 because the buyer's not getting the earnest money back. The seller's keeping the earnest money, and the seller had nothing to do with that $300 expense. Okay? Does that make sense? Do I keep it there? Does that make sense? Okay. Okay, demands for the earnest money. If one of the parties, let's say that the seller asks for the earnest money, they go to the title company and they say, the contract's terminated, I want you to release the earnest money to me. Well, they're not going to just release that earnest money. What they're going to do is they're going to send the buyer a letter, and they say, we got a request for the earnest money. What are you going to do? You're going to release it? If the buyer does not respond in 15 days, then the title company will release the earnest money. But if the buyer says, no, I do not approve giving that money back, I should get that money, then the title company says, okay, we're not going to do anything until a court of law tells us what to do. Okay? So this is just kind of all for the protection of the title company. Paragraph E talks about any notices that are sent. They're going to be sent to the address in paragraph 21, which we'll get to later as we go through the contract. Paragraph 19 talks about representation. It basically says that any covenants, representations, or warranties in this contract, they don't expire when the contract is executed. So if you go to closing and it closes in funds, that doesn't mean that everything ends. Any kind of warranties or representations that were made, they continue. Okay, so let's say that it's determined that you close in fund, and then a lot of the decisions to buy the house were made off of the seller's disclosure, and then you find out because of problems that arise with the property that the seller basically lied to you, then you do have the right to go back and sue them for four years. Okay? Okay, federal tax requirements, they changed this paragraph a little bit, not the content of the paragraph, but just some of the wordings as who is a foreign person. And a foreign person is as defined by the Internal Revenue Code and its regulations. So this is the FIRPTA, which is a law that's been on the books since 1980. It basically says that the IRS has the right to withhold proceeds from a foreign individual on the sale of property that exceeds $300,000. So there's a lot to this paragraph that really goes beyond the scope of this class. But if you know that seller is a foreign individual, then it would be in your buyer's best interest to consult a CPA on how to handle this and the best way to approach it. Okay. Because the buyer is ultimately responsible if they don't. They really should. You could ask the seller to provide an affidavit that states that they are not an illegal alien or a foreign resident, that they are a U.S. citizen. But without that affidavit, and then if it was determined that seller was, and now they're in China or Mexico or wherever, then that buyer could be on the hook for that payment. Okay, notices. This paragraph provides the way to let another party know that you're delivering them some type of notice that you're terminating the contract, or any type of notice that you need to provide to that seller. So it's a good idea to go ahead and fill out both sides. If you represent the seller and it comes in without any information in there, then you might go back and say, you know, when you make your revisions to the contract, please put my email address in there. Okay. Yes.
Sometimes agents put their contact information rather than the buyers. Is that acceptable?
It's acceptable that you're just on the hook to make sure that when you get a notice that you get it to them as quick as possible. I think, to me, to kind of mitigate risk, I would like to have my buyer's email address and my email address, and then on the seller side, the same thing. Okay. Now you'll hear different schools of thought, and I'm not an attorney. What happens if that is blank and you don't put anything in there? How can you deliver a notice? Okay, well, a lot of attorneys say that the law of agency says that if it is blank, then all you have to do is send it to the other agent, and you've delivered that notice. And then other people say, oh, no, if there's nothing there, then they can't terminate. Or if you just have an address there, then what are you going to do? Go to that person's house and say, here, I'm terminating the contract. So, okay, so I think the safest, best way is to have email addresses on both sides. And then if you're dealing with somebody that's still using a fax, well, I'm sorry about that. Okay, here's all the different amendments that might be a part of the contract. If any of those amendments exist, you just check the box. All of those amendments, with the exception of the lead-based paint disclosure, those are all TREC promulgated addendum, and those are the ones that you should be using. So you check as many of those as you have or need, and then you just attach them and they become a part of the contract. And then they left a box for other. So, you know, like we have an addendum for non-realty items, like if the buyer's going to buy the washer and dryer, the washer and dryer and refrigerator for $100, you just fill out that addendum, check that box. A lot of times relocation companies will have their own addendum, you can check that box, or maybe a foreclosure addendum, and you check that box and put the information in there. Now what you don't want to put in there is any kind of agreement or any kind of document between you and the seller or the buyer. So your information about brokered services, it doesn't belong in there. That has nothing to do with the other party, or your listing agreement or your buyer's rep agreement. Any of those things, that's just between you and the other party. That's not a part of this contract. Okay? Okay, the termination option. This is probably one of the most important paragraphs for a buyer. If this paragraph is done correctly, then the buyer has the right to terminate for any or no reason. I've seen buyers write 2 contracts and have them both accepted, knowing that they're going to be able to get out if this paragraph is done correctly and they perform according to the paragraph. So the first thing is you need both of those blanks filled out. You need an amount. You cannot have 0. If you have 0 in there, you haven't bought that right. There's no consideration. You need an amount and you need a number of days. So those are the first things that have to take place. Okay? So let's say you put $100 and you got 10 days. Then that $100 has to be delivered to the seller or the seller's agent within 3 days of the effective date of the contract, or you don't have an option. Okay? So that's kind of the third thing. You got a number of days, you got an amount, and you got to deliver it on time. Okay? So let's say you got 10 days, $100. So now I've got 10 days to have the house inspected, check on insurance, make sure I don't have any buyer's remorse, make sure I do all my due diligence and I did the best thing I could, or I can just walk away and lose that $100. Okay? Now, if I'm going to walk away, I've got 10 days, so by 5 p.m. of the 10th day, if I'm going to terminate, I've got to let that seller know. Not 5:01, not 7 o'clock the next morning on day 11, 5 o'clock, local time where the property is located. Okay? So, if I'm in California, I don't go by California time, I go by Texas time. Okay? Or if I'm in El Paso, which is an hour behind us, we go by the local time. All right? And then you see that last sentence, time is of the essence. So 5 o'clock means 5 o'clock. There's no room for argument. And that's the same type verbiage we saw back in paragraph 5, where the seller has the right to terminate if the buyer doesn't deliver that earnest money on time. Okay? If you look in the paragraph 9, when we talk about the closing date, it says we're going to close on or before a day. But it doesn't say time is of the essence, right? That's a very legal term. It has very, very, very specific meaning, and it's a term that we as agents should never use. You don't want to put in something that time is of the essence, unless you have a law degree. Have any lawyers in the room? Lawyer and a real estate agent?
Pardon?
Lawyer and a real estate agent?
Yes.
Wow, look at that, a double whammy. I'm glad we didn't say anything bad about lawyers tonight.
It's all true.
Yeah, they're not bad guys. Okay, then we're almost at the end here. Paragraph 24, consult an attorney before signing. It basically says that TREC prohibits us from giving any legal advice. You need to read this carefully, and then if you want to list your attorneys there. Hardly see anybody put any information there. I think you'll find out as you work with buyers and sellers, they don't know a real estate agent until they meet you, and then don't let them forget you. They don't know an attorney, and they don't know a police officer for the most part. So I've never seen anybody put any information in there. And then this is very important, that the contract be dated. How many contracts get over to the title company and they're not dated? Who's supposed to fill in the date? Well, it doesn't say. It just says the broker. Which broker? There's 2 brokers involved. Okay. So can you fill in the date as an agent? Yes, because you're an agent for that broker. So yeah, you fill in the date. But it has to be filled in, and then you need to let that other agent know that you have dated it, and this is the date, so that there's no misunderstanding that May 7th is the date of the contract, because there's so many dates that start running off of that day. So if you leave that blank, do you still have a contract? Yes, you have a contract. You just don't know when the option period ends. And you've got 2 agents that are probably in some hot water. Okay, that's when you get your brokers involved, and that's when you get the buyer and seller involved, and you try to come up with a date, because you don't want to go to court and have a judge tell you when the effective date is, and then the next thing, you're up in Austin trying to convince TREC that you really are competent, you just forgot to put in the date. And they don't make it very obvious. They put a box around it, they put it in bold print, and then it's in all caps. So I think they're trying to draw your attention to that box. But we see it all the time. Okay, the broker information. If you're an agent, if you represent the buyer, you fill in the left side, and you represent the buyer as the buyer's agent, or you're a sub-agent for that buyer, and then fill it out completely so that the title company has all the information that they need in there. Okay? And then if you represent the seller, you fill out the left-hand side, and then you represent the seller as either the seller's agent, or you're an intermediary where you represent both. Your broker represents both the buyer and the seller. And then you list the one agent involved if you're just representing the buyer, the seller as the seller's agent, or if you're representing the seller and the buyer, then you fill that out completely. 5 minutes. And then whatever commission has been already agreed to, you put it there. This is not binding on anyone. As a real estate agent, what's binding is what's in MLS. So this is just reaffirming what was already published in MLS, that's the commission you're going to pay. 3%, 1%, $1,200, $50, whatever commission you've agreed to, that's what goes there. Okay. And then if it's an intermediary transaction, you don't put anything in there because there is no other broker. It says listing broker has agreed to pay the other broker. There is no other broker. Okay. The next box is for the seller or the seller's agent to acknowledge that they did receive the option fee. This is another change they made to the contract that goes into effect on the 15th. Now there's a place to receipt the earnest money separately from receiving the actual contract. So to me, this part up here is real important, that it's dated and time-stamped when that title company actually received the earnest money. Because you remember back in paragraph 5, the buyer now has the right to terminate if it hadn't been received within that 3-day period. And then the contract receipt, and then if there's any additional earnest money, it's receipted here, okay? Does anybody have any questions? Is everybody okay? I appreciate you being here. Do we have any agents that came in after we kind of got started? Okay, there's a sign-in sheet up here. You guys were here in enough time, but if you want to come up here and sign, you get the CE credit. You don't have to sign out. If you signed in, that's all you need, and it'll be updated with TREC probably tomorrow or Wednesday at the latest, okay? Thank you guys for being here. We appreciate you.